Hi everyone, my name's Angela Backhouse from Chamberlains Law Firm, and today I'll be giving you some information about your will drafting and estate planning. So to start with, I just wanted to talk about why there are so many people that don't have a will. In Australia, there's many people that don't have a will, and I often have people come and see me, maybe for other matters or even just talking to them socially, who say to me, I really need to come and do my will. And that's something that seems to be on everybody's to-do list, but is never actually actioned by a lot of people. So one of the reasons is because they just don't understand the importance of having a will. And the reason for that is that they think that it will all be sorted out once when they die, that their family knows what they want and they will just look after it when they pass away. Other times it's because they don't actually want to think about dying. They're concerned about if they prepare a will, they have to think about what will happen if they die, and some people think that that might be a bit of an omen for them, so they want to delay that as much as possible. Some people just think that because they're young, they don't need to worry because the likelihood of them dying is very minimal, and so it's something that they will do once they're older. A lot of people are worried about the cost of preparing a will. Obviously, we all have pressures on us from a financial perspective, and so it can be difficult to fit that into your financial budget. For a lot of people, it's about keeping it on their to-do list, but they just never have the time to actually get to it on their list, and they never actually give it the priority. So I do know a number of people who plan on doing their wills at some stage, but just never really get around to it. So what triggers people to actually make their will? Normally it is a significant event in their life. It could be that they are buying a house, that they have, they're getting married or they're getting divorced. It could be that they're having children. It could be that they have a friend or family member that has died or suffered a health issue of some sort. Or it could be that they have a health scare themselves, or being diagnosed with an illness which triggers them to actually go and do something about their will. It could also be because they're travelling overseas, and they're concerned about something that might occur when they are overseas. So all of these reasons are reasons to start thinking about doing your will. They often will prompt people to do their wills, but they're also a reason to update your will if you already have one. So what is estate planning? It's not just about drafting a will. That is just part of the overall estate planning process. Estate planning itself also includes considering other aspects of your succession planning and providing complete advice to you in regards to what your current asset structure is and how it needs to be set up to make sure that your wishes when you pass away are going to be met. It also involves preparing wills, which could be simple or it could be complex or somewhere in between. And we also undertake an exercise of reviewing associated asset holdings and trust deeds and companies and other interests in assets that you might hold, whether they be jointly or in your own name, to assess any variations to those existing holdings that need to be done at the same time as your estate planning process is taking place. The things that we also consider during this process is potential and actual claims and potential claims for family provision, which is where, despite what you have in your will, a dependent someone who's dependent on you and who fits a certain category could make a claim against your estate if you've not made adequate provision for them in their will. So we do discuss that with our clients to talk about what can actually be done to protect your estate from those claims, or at least minimise the risk for the people that you actually want to receive your money. We talk about the potential if you've got disabled or potentially irresponsible beneficiaries and you want to protect them or put somebody else in charge of what they're actually receiving so that they don't have the control. Sometimes and quite often we have situations where people want to give a life interest in, say, a residential home to somebody else, but they don't want that person to receive the outright interest in that home, and so we can build that into your wills as well. And also we look at any changes that might be required to your current business structures, if that's applicable, to make sure that your business it goes through to who you want, and to make sure that the control factor is there as well. Other parts of estate planning include considering where your superannuation money is, and a lot of people don't realise that their superannuation is worth a considerable amount of money, especially when you include the insurance policies that are attached to the superannuation policies. And we also look at any life insurance policies that you have. While superannuation and life insurance will fall outside of your estate when you pass away, they can still have a very significant impact upon the people that you want to receive any money when you pass away. And so we need to consider that to make sure we're having a holistic view of what's happening with your estate when you pass away. So, what is will drafting compared to estate planning? A lot of firms will give you a will drafting, which is a simple process for a fixed flat fee, which might be a smaller fee. And that is essentially just gathering information, your name, your address, details of your beneficiaries, and instructions from you on what you want to happen. They will put all of that into a precedent. They'll attend upon you to get it signed, and it's a very much a document processing process which doesn't get too involved in your personal affairs. Obviously that comes at a cheaper cost. Estate planning is a more detailed review of what are your assets, what is your family situation, what else do we need to do to make sure that your assets are going to be protected when you pass away, to make sure that the people you want to have control and ownership of your assets are going to receive that, and putting together a document that's not just a simple template, but also takes into account all of these extra factors that apply. So the types of wills that we deal with are if it's a single person that just needs a will on their own, it will just be a single will. If there's a couple that comes to see us that wants to make sure everything happens mutually, that when one person passes away, no matter who passes away, the same result will happen first and foremost, and that's what we call a mutual will. Then we have more complex wills, which may include things like discretionary testamentary trusts and life interests that I was talking about earlier. So why do you need a will? As I said, some people are of the belief that they don't need a will because they've already told their family members what they want to happen with their assets. It doesn't seem to be a big deal to them, or they might say, I don't really own that much anyway, or mostly all I have is debt, so it'll all get sorted out. But the main reasons to have a will are firstly to avoid disputes. As I said, even if in your own right you may not have substantial assets yet, you've got to remember that your superannuation does hold significant assets, including your life insurance policy that's attached to it. Now, depending on what you've done with your superannuation and whether that's going to be paid directly to your beneficiaries or into your estate will determine how much your estate is worth at the end of the day. But these are factors that need to be considered so that you can decide what you want to happen with that money. what we find is that most of the disputes that occur with estate litigation occur for estates that are not worth substantial amounts of money. So it is very common for families to argue over perhaps an estate that's worth $400,000 or $500,000 and get into large disputes about that. And at the end of the day, if that does get into a litigation, then it's the estate that has to pay for those costs. And so the beneficiaries and the people you wanted to receive that money are the ones who are going to suffer at the end of the day. So in addition to that, by having a will, you're going to minimise the costs of the estate. If you don't have a will, you have to go down the intestacy avenue and obtain letters of administration through the court. This can be a more costly process, and whereas if you've got a will, that makes it a much more simpler and cost-effective process. It makes sure that what you wish to happen with your estate will happen. Otherwise, you're leaving it in the hands of the legislation that applies. Despite what you may have said to your family members at some point about your wishes, if you haven't put it into a proper will, it won't take effect. And I'll talk about what makes a formal will in a minute. You get to choose who will control and administer the estate. So that's the person who gets to call in all the assets and control what happens with those assets, obviously in accordance with your will. But at the end of the day, that's the person that has that level of control. If you don't have a will that appoints someone to have that control, then it's open for somebody to make an application and potentially some arguments around that as well. Sometimes even with a will, if it's not up to date or current or hasn't been drafted properly, you could end up with a partially intestate estate. And that means that you could have part of your estate dealt with under the will, which is valid, and then the rest of your estate that hasn't been validly dealt with under your will has to go through an intestacy process. So that's another reason why making sure your will is drafted properly and by a lawyer is extremely important, because at the end of the day, even intestacy laws as a whole could be better than having a poorly drafted will. So moving on to intestacy laws. Intestacy laws are different in every jurisdiction in Australia. They govern on a state-by-state basis. Today I'm just talking about the New South Wales intestacy laws. In other jurisdictions they're relatively similar, but there are a few differences. Firstly, if somebody dies and leaves a spouse but no children, then that spouse will receive all of the estate. If the deceased leaves a spouse and children, and the children are the children of that spouse, then again the spouse will receive all of the money of the estate. If the deceased leaves a spouse and children, but the children are not the children of the spouse, then the estate starts to get split up. So the spouse will only receive personal effects of the deceased, a legacy of $350,000, which is adjusted for CPI, and any interest if that's not paid within 1 year of the date of death. Aside from that, the balance will get distributed between the children equally. Then if you don't have a spouse, you get to dividing equally between the children. If there are no children, it goes to parents. After that, it could go to brothers and sisters equally, and then we keep going further and further down the line. So the next one is grandparents. After that, it's aunties and uncles, and then we get to first cousins. And they're the cases you hear of your friend who was contacted by some long-lost relative to tell them they've received some random inheritance. Finally, if we've exhausted all of those avenues and we still don't have anyone to distribute the estate to, it will go to the government. So that obviously adds a level of complexity, whereas if this was all set out in a will, you don't need to go through that process. Some of the issues that arise with intestacy is determining who is the spouse. There could be a situation where someone has potentially two spouses. There's been many cases where someone has separated from their husband or wife, moved in with a new partner, but not formally separated with their previous husband or wife. They haven't, gone through that separation process yet. And then the question is, who is the spouse? Are there two spouses that now need to share in the estate? There's also a question around whether somebody is in fact a spouse. A de facto spouse may be clear in some instances, but in other instances may not be clear. You might get a case, particularly we find sometimes with elderly couples who get together later in life, potentially after their husband or wife have passed away, and they start seeing each other but decide to live separately. So then there could be a factual issue around whether they are in fact de facto spouses, and that then means that evidence needs to be brought before the court to prove that that relationship existed, and you could end up in a dispute between the de facto spouse and the children around who's actually going to receive that inheritance. With intestacy, stepchildren will be excluded, so they don't get to participate in the distribution. And there's also a question mark around who will actually administer the estate. So it's not made clear in the legislation exactly who can apply, because there could be a variety of people that are entitled to do so when you pass away, and there could end up being a dispute around who could apply to administer the estate. So moving on to what is a valid will. As I said to you before, it's important to make sure when you draft a will that it's done in the proper formal requirements, and that you have it all signed and witnessed correctly. So under the legislation, a formal will must be in writing and signed by the testator, and that needs to be on every page of the will. It also needs to be witnessed by 2 independent witnesses in the presence of the testator. So it's very important that all 3 of those people are in a room together, and they don't leave that room until they've all signed all the pages of the will. Those witnesses must be independent, so having someone who's also a beneficiary under the will, or a potential beneficiary, could also be problematic. Finally, the testator must also be of sound mind and understanding. So if there are questions around their capacity at the time, it could be important to actually go and get a letter from a doctor on the day of signing their will to confirm that that person does have capacity. And that could be in situations where someone perhaps has early onset dementia or Alzheimer's, who's not necessarily suffering from the disease to a significant effect at that time, and might well have the capacity to sign a will. But because there are potential questions around it and the potential for someone to argue the validity of the will, it's important to have that verified by a medical practitioner at the time and avoid that dispute later on. Other examples of wills are informal wills, and there are many, many cases where wills that have not met those requirements that I just set out have in fact been accepted by the court as being wills that could be enforced. Obviously, that's an extra process and a more costly process, because the executor in that case will need to go to the court to get approval for that will to be followed, and certain evidence might need to be produced in connection with that. Some examples of that are an unsent text message in the case of nickel and nickel. That is where the testator had actually typed out a text message indicating their wishes and didn't actually send the text message prior to their death. The court in that case did find that informal will was a valid will. That was a departure from previous understanding of the law, and that was a significant case in that instance. There's been cases where audio recordings have been found to be valid will. There's also cases, and one of the main cases on the subject, Drummond and Drummond, where notes were taken by a friend and then they were signed by a testator, but not formally witnessed. So when do you need to update your will? Even if you have an existing will, you should always be looking at your will regularly to make sure that it is updated and current in case you pass away. And I always say to my clients, you need to prepare your will as though you're going to die tomorrow. Don't do it in anticipation of things happening in the future, because you don't know when you are going to die. And we all hope that doesn't happen tomorrow, but we need to work on that basis when we're drafting the will. So important times to consider updating your will is if one of your named executors or beneficiaries has died or become incapacitated and would no longer be able to prepare their will, to execute the will. Could be divorce or marriage. If you get married and you have an existing will in place, unless that will was prepared in contemplation of marriage and expressly stated as such in the will, then that will become invalid immediately upon the marriage. Differently with divorce, once you get divorced, the will remain valid, but any gift that you have given to your ex-spouse will no longer be valid, and therefore that could create a partial intestacy depending on how the will has been drafted. It's also usually likely that you will have appointed your ex as your executor of the estate, and unlikely that you would want that to continue. If you sell or purchase a major asset, it is something to consider to make sure the asset is purchased in the right names correctly, and whether it's joint tenants or tenants in common will have an important effect on your estate. So that needs to be considered. With the birth or adoption of children, your current will may not deal with children, whereas once you have children, you need to make sure they are dealt with. But in general, even excluding all of those issues, we suggest that you do review your will every 2 to 3 years, pull it out of the cupboard, have a look at it, and make sure it's still current today. So talking about the will, the estate planning process, I just sort of go through the information that we normally request from a client when we are taking them through this process. So we will ask about information about assets. We want to know if you own your own home. If so, whose name is that in? Is it in joint tenants, tenants in common? Is there money in the bank? Are there several accounts? Are there joint accounts? Are they separately held? Do you have investments, share portfolio, other sorts of investments, whether there's companies or trusts that exist. If there are companies or trusts, we like to look at an asset search to make sure we know what the shareholding is, whether that's held in its own right or beneficially, and we look at the trust deed if there's a trust in place to have a look at what will happen with the assets of the trust. It's very common for people to believe that assets that are held in their trust are assets that they can gift away under their estate, but in actual fact, if you have a discretionary family trust with assets in that, you really have limited control over what will happen with those assets once you pass away. So we then need to look at who will have control of the trust once you pass away, and may need to make amendments to your trust deed as well. So these are all factors that we look at. We talk about who you will want to appoint as your executor, and as I said before, that's the person that's going to have control over the estate once you've passed away. So they will step in to effectively hold the legal interest in all of your assets for the benefit of the beneficiaries, and they then must do with those assets what they are required under the will. We ask if you've got minor children, who will be the guardians of those minor children if you pass away before they turn 18. And that's usually something that people will want to discuss with the proposed guardians and make sure that they'd be comfortable with that. You might even want to set up a guardian fund to make sure that there's expenses covered and things like that, to make sure that the guardians are not out of pocket. Then we talk about who the beneficiaries will be. And for a lot of couples who have children, it's a relatively simple approach of saying, well, I want everything to go to each other, and then I want our children to receive everything equally. That's a very standard, straightforward case. But then we get to a situation, particularly if those children are minor children, of asking, what do you want to happen to your estate if yourself and your children have passed away? And that's because when they're minor children, you'll often be travelling together, and there's more of a likelihood that you could all pass away in a car accident or so forth. So that's often the more trickier question for people to think about, what they would actually do with their estate if them and their children had passed away. We also talk about the age that you want your beneficiaries to take control of their estate. The courts will, if applied for, grant anyone who's over the age of 18 the power to control their own estate. But in the absence of making that application, you can set a date in your will that you don't want them to actually have control of those assets until they reach an older date. And a lot of people prefer that if they're concerned that their children at the age of 18 won't be responsible enough to look after the large sums of money that they will receive. When it comes to more complex wills, the things that we look at are testamentary trusts, and I'll talk about that in a little bit about what the benefits of a testamentary trust are. But the idea of a testamentary trust is basically taking the money you're giving to someone and putting it into a trust that's created in your will, and the terms of the trust are set out in the will, and you determine who's going to have control of the trust assets. And as I said, I'll talk about the benefits of that in a moment. Other things in more complex wills are life interest or a right of residence. So you might have a partner who you want to continue living in the residence that you own personally until they pass away. But once they pass away, you want your children or somebody else to actually receive the benefit of that property. So there's various ways that can be dealt with, even to the extent of providing for substitute properties if that person with the life interest actually wants to move house at some point. So all of that can be built into the will. And the idea being that we want to try and minimise any dispute that might occur between the person with the life interest and the eventual beneficiaries, because those things can be prone to problems if you don't put enough information in there. Sometimes we might need to look at special needs funds, particularly if you've got beneficiaries who have got a disability. There could be a will that you're excluding a dependent or a child, and in that case we need to really carefully consider the family provisions laws that apply and what steps can be taken to try and minimise the potential for a family provisions claim. We can do wills in anticipation of marriage or divorce and make sure that they will continue to be valid after those events occur. There are situations where people have complicated gift structures, where you might have money in various interests, investments, funds that you want to split between different people in different ways, or with interest to be calculated and things like that. There's a whole lot of detail that you could go into, but does make the will a bit more complex. And some people do like to put in extensive funeral wishes. We normally recommend against putting too much information in your will around your funeral wishes. And the main reason for that is because sometimes the funeral will be prepared pretty quickly after your death, and it may be the case that nobody actually looks at the will until after your funeral, and that could cause some concerns for the people who are appointed as your executors, if that's the case. Other considerations that we have when we're doing estate planning is to consider superannuation and life insurance. So as I said, both of these things will not automatically form part of your estate when you pass away. With your superannuation, you can sign a binding death benefit nomination, which nominates your estate to receive the proceeds of your superannuation, but that is a separate document and forms that need to be completed with your superannuation fund. So we do sit down and take you through that and discuss the benefits of either directing that money into your estate or alternatively giving it directly to your beneficiaries. And when I talk about potential for family provisions claim, sometimes that can be a useful mechanism. If you are concerned about a family provisions claim, we can redirect the superannuation money away from your estate, and that can assist with minimising any potential claim on your estate and making sure that the people you want to receive the money are actually going to receive it. Also, which can be relevant for people who are in the public service, is the impact of the CSS or the PSS and how that can be dealt with, which has certain limitations as well. So the benefits of a discretionary testamentary trust are that several reasons why people will decide to put one into their estate. Often it's because it will provide flexibility for the beneficiaries when they receive that money. They can use that as an investment to invest in other assets, and the huge benefit of it is that it has income tax benefits when you have beneficiaries in there that can receive that income and get the benefit of tax-free thresholds. So examples could be when you have someone who's at university or so forth that is not earning a huge amount of money, you could potentially distribute some of the income of the trust to that person in any particular year, to try and minimise the tax that needs to be paid on the income of the trust. So when we prepare the discretionary testamentary trust, the main beneficiaries, the primary beneficiaries, will be named. It might be your 3 children are going to be the primary beneficiaries of their own testamentary trusts, but then there's a whole heap of secondary beneficiaries who may have the potential, at the discretion of the trustee, to receive income from that trust from year to year, and that might include the beneficiaries' children, grandchildren, related entities, brothers, sisters, the list goes on. Other reasons that people choose to do it are for asset protection purposes. So putting the assets into a trust might assist if that beneficiary ultimately is put into bankruptcy, and also if they're going through a divorce situation. So that has some benefits of doing it that way as well. The other things that we talk about when we're doing estate planning, once we've moved on from the will and what will happen on your death, is also talk about powers of attorney, which a lot of people phrase as a living will. I think that's probably an anomaly because it's not really a will. It is giving somebody power to do things on your behalf while you are alive, but it's not essentially giving anybody any of your assets. So a power of attorney will effectively appoint somebody else to take control of your affairs and give them that power to step in if you lose capacity or in any other circumstances you choose for it to come into effect. And they can access your bank account, pay your bills, buy and sell property if you need to be moved, that kind of thing. In New South Wales, there are 2 separate documents. You have a power of attorney which deals with your assets, and you have an enduring guardianship that deals with your personal and medical issues. And so that person who deals with the enduring guardianship can make decisions around where you live, what kind of medical treatment you receive, dental treatment, and whether life support is disconnected and things like that. So normally you want to appoint someone that's very close to you, that's going to have your interests in mind. For most couples, they will appoint each other initially, and potentially if you've got adult children, you can appoint them as your secondary attorneys and guardians. Alternatively, people will look to other relatives or close friends to take on that role, just noting that it is a important role and could be quite a stressful role, and is generally an unpaid role. So I normally recommend to have a discussion with those people first. At the end of the day, when we draft the documents, whoever you nominate also have to sign the document to accept the appointment, but you also don't want to just land that on them and expect them to take it on. Just finally, the other things at Chamberlains Law Firm that we do that relate to estates, there's quite a lot of things that we can assist with. Firstly, we assist with estate administration once someone has passed away, assisting the executor or the administration to manage the estate, put it through the court to get the grant, and then look after the sale of assets and distribution of assets. We can assist people with family provisions claims, so people who think that they have not been made adequate provision for under a will or even in intestacy laws can make a claim on that estate. We assist people with elder abuse, which is becoming quite a common issue in our day and age with an ageing population. we do assist people with discretionary family trusts, which are trusts that are set up while you're alive, and we can help them to review and vary those deeds if they need to, particularly for estate planning purposes. We can also assist with variation of testamentary trusts that have already come into existence. So if you've received the benefit of a testamentary trust, or if you've been appointed as the trustee of a trust under a will, you might need assistance and guidance in terms of managing that trust going forward, and sometimes amendments or variations need to be made to the terms of the trust. Other things that can come up is the severance of joint tenancies. So we might find that a property is owned as joint tenant, which means that when one person passes away, the remaining person is going to receive that property in full and it won't form part of the estate. That may not be ideal in the estate planning process, particularly if you've got a blended family and you want each person's shares to go to different people. So we may need to actually sever that joint tenancy and create a tenant in common situation. Just finally, I just thought I'd touch on a few of the questions that had come up here. There was a question about what happens if someone dies and they're bankrupt. There could be a lot of different scenarios that occur in that instance, and it may require a sequestration of the estate itself. There could be other scenarios, depending on the extent of the debt, where the creditors will be notified of the fact and will in fact just write off those debts without going through the formal bankruptcy process. But it will depend on the status of the bankruptcy, whether it's already in effect or it's just the fact that that person was technically insolvent at the time. And will also depend on what the amount of the debt was. So that can cause some complications. We also have instances where named beneficiary could be bankrupt, and in those circumstances it may be an obligation of the executor to actually pay the distribution to the beneficiary, to the trustee in bankruptcy. So another factor to consider when we're drafting wills for people is, is one of your beneficiaries in bankruptcy? And if they are, or is there potential for them to go into bankruptcy soon? And if so, do we need to look at doing something different with their gift to avoid it going to the trustee in bankruptcy rather than it going to somewhere else? And there's various options that you could find there. The other question was, who is eligible to make a family provisions claim? I won't go into family provisions claims in detail because that's probably a whole nother CPD topic. But one of the, so the main thing is for family provisions claims is, firstly, you need to be a dependent. And you have to show that you had that level of dependency on the deceased at the time that they passed away. And then you have to fall within one of the categories of a person who's eligible. So that might be a child, or if that child has passed away leaving children, it could be the grandchildren, or there could be, there's a few other different categories that could be eligible family members. So it really just depends on the level of dependency then. And then the final thing that the courts will look at is, has adequate provision been made for them in the estate as it is, or does an adjustment need to be made to the estate in order to make sure that proper provision has been made? And I think that's about all. So I'll finish up there. Thank you very much for watching and listening, and please contact Chamberlains Law Firm if you have any questions about estate planning.